Hello, my name is Jay Miller. I'm a practitioner in Whitefish Bay outside of Milwaukee, and I specialize in tax controversy work. Previously, I was vice president and tax counsel at Northwestern Mutual in Milwaukee, and prior to coming to Wisconsin 21 years ago, I was a trial attorney in the tax division of the Department of Justice in Washington, D.C. Today I'm here to talk to you about recent developments affecting the attorney work product privilege. And those developments come from what would appear to be an unlikely source, the tax area. However, the ramifications surrounding these developments are such that it definitely could have a bearing upon practices and litigation activities for non-tax practitioners as well. The attorney work product privilege stems from the 1947 case of Hickman v. Taylor, which most of us studied in law school, and was then later codified in the Federal Rules of Civil Procedure, which provides that absent substantial need being shown, that one party cannot ordinarily discover the work product of another party's attorney that's prepared in anticipation of litigation. And the federal rules go on to provide that a court must protect against the disclosure of an attorney's mental impressions. And one court added that an attorney's mental impressions are, quote, virtually undisclosable, close quote. So it's apparent that that's a very high bar. And it may be so, but the fact is that the IRS and a couple of courts have really called that into question. And as we'll see, it may take the Supreme Court to straighten things out. Early in 2010, the IRS issued an announcement requiring businesses, corporations filing income tax returns with assets of over $10 million to disclose to the IRS its uncertain tax positions, those positions for which it's less than absolutely certain what the correct tax and legal result is. They needed to disclose this information provided that they had filed reserves for those positions with their financial accounting statements. And the thing that was really surprising was that the IRS also required that these companies must disclose why their tax positions were uncertain, or if you will, suspect, without regard to the fact that the assessments for determining whether a tax position was uncertain or not quite often would come from an attorney for these taxpayers, advising them with regard to the risk of litigation. Now, some courts have said, two appellate courts in particular, have said that this type of work product is protected from discovery by the IRS under the work product privilege because the content of the material deals with litigation. But a couple of other appellate courts have said that it's not protected because even though the content involves litigation, it's being provided in a non-litigation context. In other words, to advise the companies regarding their financial accounting statements. So you have this conflict, if you will, between content and context. In any event, because of what the IRS did and because of the uncertainty created from these court decisions, the IRS created quite a furor. Not only in the tax community, but the legal community at large. And the American Bar Association itself weighed in and said that what the IRS did was inimical to the work product doctrine. So that's pretty strong language. And because of that, perhaps, they didn't say why, but in any event, towards the end of last year, the IRS sharply retreated from its earlier announcement and came out with a revision, which says that no longer would they require companies to disclose to the IRS why their positions might be suspect, or even to say what was the total amount involved at risk with respect to those positions. However, companies who otherwise fit these criteria still need to disclose in what the IRS calls a concise description what these uncertain tax positions are. And they have to rank them based from larger to smaller amounts based on what is the amount at risk, or what are the amounts at risk. So because of that, some would still say that there's a turning work product that's embedded in all these decisions that have to be made, and questions remain. And as I said at the beginning, this doesn't just involve the tax arena, it also involves non-tax area as well. And I'll give you an example that's taken straight from a court case, where it was pointed out that, let's say you as an attorney are advising a client who is considering the publication of a book. And it turns out that another company purportedly has the exclusive publication rights to that book. And the advice that's being rendered to the first company is reviewing what are the risks of litigation if they in fact publish that book. But it's being provided in a context unrelated to litigation. It's being provided so that that company can decide whether to publish the book in the first place. So when you have that situation, some courts, as I said earlier, would say that's protected. The advice that's being given is protected under the attorney work product doctrine. Others would say, no, it's not, because it's not in the context of preparing for litigation. So I think you can see how widespread the application or implication of these cases are. In any event, because there's this conflict between and among federal circuits, it makes it more likely that the Supreme Court at some point is going to take this up. And they certainly have, starting with Hickman, have weighed in on the attorney work product in other areas. The Seventh Circuit, just so you know, has not rendered an opinion in this type of situation yet, dealing with the doctrine. So it's important for all of us here in Wisconsin to keep our eyes open to see what happens here. For more information on this subject and for some suggestions on how to protect a turning work product, regardless of which tests might be applied, I recommend that you read my article in the October edition of the Wisconsin Lawyer. Thank you.